So I got a call from a longtime client, all freaking out saying, hey, did you hear about this corporate Transparency Act? And we got to move on it now. And he was all worried about it. And I was like, well, hold on a second. You know, doesn't really go into effect until beginning of next year. Mm-hmm. But we have now, word's gotten out. Everybody's freaking out about this. And you happen to be somewhat of an expert on this. I think you're presenting at an upcoming seminar on this topic.
Right. Yeah.
So what is the Corporate Transparency Act? Let's start there.
So the Corporate Transparency Act has actually went into effect under the last administration. It was passed by Congress. Trump tried to veto it, and the Congress overrode the veto, which tells you that Congress was really adamant that this act get passed. But in its nature, Corporate Transparency Act is a disclosure obligation, and it's requiring that basically any executive officer or any owner over 25% of a private entity, unless there's some exemption, we can talk about that, has to file a disclosure on behalf of an entity to the federal government, the FinCEN, letting them know who these people are, what their address is, and basic information like that. So on its face, you think about it, well, this is me just reporting, who I am and my address to the federal government. They already have that stuff. What the federal government hasn't had before in a very organized way is who are the people really behind these entities that are operating the entity. And I think it's helpful in talking about this to start by explaining what the situation is now, or how this works today. But before I talk about that, I want to touch on why. So the why behind the act.
Okay.
And the why is, for decades now, there are lots of organizations or people, or the government considers bad people, that use entities to kind of hide their holdings from law enforcement. And so, like, the worst case scenario, or like the textbook scenario, if you're the government, is, there's these oligarchs or extremely wealthy people who are bad guys around the world that will own real estate or other investments or holdings, and they'll own it in an LLC or a corporation or the foreign equivalent. And that entity will be owned by, let's say that was in Ukraine. This was a bigger story more than several years ago with these Ukrainian oligarchs, right? They would own those assets in an LLC, or Ukrainian corporation, that would be owned by some entity from another country. And then that entity would be owned by an entity from another country. Then it'd be owned by an entity in the Cayman Islands. Then it'd be owned by a Delaware corporation. And so to unpack the ownership of this tract of real estate that was being occupied by, this bad guy would be really hard for the government to go prove. They don't have a clear way of showing ownership. So there's a lot of frustration on law enforcement to kind of try to make this easier on them to figure out who are behind these entities. So that's the extreme scenario, right? And maybe that's an unfair picture to paint for every honest, hardworking business person who likes the benefits of holding his business in a limited liability company or corporation, and the benefits of that. But in the United States and in many countries, the ownership information of your entity is private, and they're fairly easy to form. I know you've probably formed them before, Avo. It's a matter of going on the Secretary of State website of a particular state that you want to form in, providing a name of the company, who the registered agent is, which is somebody who collects notices and other government, or if you ever get a lawsuit filed against the entity, there's a place to serve that entity. And at least for in Delaware, that's basically it. That's the public information. Other states have other additional requirements of disclosures of who are behind entities, but it's pretty limited. And then the federal government really only knows who's behind the entities when you file a tax return. So if you don't have an obligation to file it or you're not filing it, the federal government doesn't know. So it's been hard for law enforcement to say, okay, we have this company. It seems to be tied to all this nefarious conduct. We can't prove that this company is affiliated with these people. There's no paper trail. And when we go and depose these people, they say, I don't know. And my lawyer or my accountant, knows, but I really don't know. And so all these practical roadblocks to figuring that out. Plus, if you think about law enforcement, there's not probably a large team of lawyers helping them, forensically understand entities and what questions to ask, right? So there's all these practical difficulties for law enforcement for entities. So we get to this point in time in history where law enforcement is pretty fed up. And so they go to Congress, and they've been pushing it for a long time to try to have some type of obligation for entities to disclose who are behind the entities. Ultimately, who's the president, who's the CEO, who's the CFO, who's the general counsel, and who are the major owners of a company.
Yeah. So obviously this is, when you mention FinCEN, first thing that comes to mind is anti-money laundering.
Right.
So they're worried about things like that. Now, this idea isn't necessarily new. I could tell you in the financial services world, so if you're forming an investment advisory or an insurance agency with the state, you have to let them know who owns more than 25% ownership in the company. And with public securities, if somebody owns more than 5%, they have to disclose, right? So this isn't a brand new idea. It's just that it's being funneled down now to pretty much every business owner. And correct me if I'm wrong, the United States is actually behind on this. Other countries already have something like this in place.
Yeah, I mean, there's a big kind of international law enforcement push. And there's other countries that have it or are more aggressive about it. There's some, obviously, that still probably thrive off of the fees that they generate from having a more kind of a private structure. But the U.S., with the economic power that it is and the amount of money that goes through it, is a big, is some, what am I trying to say? It's a big, it would be a big win for law enforcement agencies to be able to have the U.S. forcing people to disclose.
Sure.
And the U.S. is a great place to hold assets.
Right.
And we see that over the last 100 years, right? All these people from all these other countries, where they want to keep their money in the U.S., where they want to buy real estate in the U.S.
Right.
And so the U.S. coming along and saying, well, if you own this entity in a corporation or LLC or LP or one of these different entity types, you have to disclose it. It's going to disclose a lot of information about a lot of people or require them to do so.
Yeah. And so this database that they're creating, I think I read somewhere it's called the BOSS, BOSS. That's
right.
the acronym. So this database will be available not just to U.S. authorities, but they're going to share it with their international partners. Is that true?
Yeah. So my understanding is it's private to private citizens, but it is a database that will be shared globally among different law enforcement agencies. It also is a database that will be shared among financial institutions. From what I understand, if the person authorizes the disclosure. But I mean, I imagine every bank's going to say, well, if you want to have an account or anything, you need to authorize me to have access to the system.
Yeah.
So you're right. And it's going to be a massive database, right? There's hundreds of millions of entities.
Yeah.
That are formed all. I mean, it's incredible the amount of information that they're trying to collect.
Yeah. And so you mentioned this started under the previous administration, so it's at least over 3 years old, and it's making its way through regulations. And it's, I think the first reporting period, we'll get to here in a second, but starts by January 1st of 2024.
Right.
And I'm assuming there's already a bunch of lawsuits against this, different organizations trying to stop it. Any updates as to where that is?
There's different lawsuits that are trying to make various constitutional claims. it's a little hard at this point from kind of a ripeness standpoint because it's not in effect yet.
Right.
So it's to make a preemptive kind of argument is an uphill battle because no one's harmed yet.
Right.
And so we'll see if once it goes into effect and someone can actually claim, well, I'm being harmed by this, if that starts to increase the pressure. And there's different aspects of this law we can talk about that kind of make it pretty difficult from a practical standpoint to make sure you're in constant compliance.
Yeah, so let's talk about that. Okay, so we understand the why. And I think a lot of the fear or confusion arose from, oh, how do I go about reporting this? I don't know what to do. Right. And word got out that if you don't comply, you could actually go to jail.
Right.
And so people are, rightfully scared at this point of the unknown. So what do we know at this point? So starting in January 1st of 2024 is when folks have to start reporting. So walk us through what's going to happen January 2024.
So for entities that are formed after the new year, you have to start complying right away. There was a bulletin that actually came out today that said compliance you might have to file that report within 90 days after the entity opens, but the general rule is 30 days. And so then that 90-day rule hasn't gone into effect yet, and it'll only be for that 1 year. So the general rule is you file the form in LLC, you have 30 days to file this report with FinCEN. And it's an online system. You would go online, you'd put in the key person's name, address, and a copy of a government-issued ID, more or less. That's what you're disclosing. And you have to do that within 30 days. If not, you're in violation. And the penalty, there's civil and criminal penalties. The criminal penalties are you can go to jail for up to 2 years and up to $10,000 fine. And then the civil penalties, I believe, are $500 a day. And those aren't capped.
Yeah, that's interesting because I read that somewhere. It said that, $500 a day, but you're not capped at that 10,000. That 10,000 is on the criminal side. Right. So realistically, that $500 a day adds up really fast.
Yeah, you forget for 2 years to file it. All of a sudden, $500 a day.
Yeah. Okay. So these are new companies that are formed after January 1st. They got 30 days. What about existing companies right now? Yeah. And existing companies.
Existing companies will have a year to comply. So they'll have until January 1, 2025 to file the report.
Okay.
So if all you have is like 1 or 2 LLCs, something that you could probably take in stride, right? Get with some professional advisors, make sure you're filling it out correctly and going ahead and filing it. The people who have these very complex entity structures are the ones that the cost of compliance is going to be high. It's because you'll have to look at every entity in that chain of ownership and see whether you're exempt or not.
Wow. And I'm looking at the exempt companies here. And they've defined the act itself and the final regulations, 23 types of entities that are exempt. Mm-hmm. And I'm just looking over public companies, okay, securities and commodities exchanges and securities clearing companies. Okay, that makes sense. 501c tax exempt entities and their supporting organizations, governmental entities, banks, credit unions, money transmitters, venture capital funds. That's a surprise one. Venture capital funds have an exemption. What do you think that is?
Well, if you can kind of see the trend in that list, a lot of those, and I'm guessing some of those venture capital funds do under different acts, they already have a reporting obligation, like you mentioned earlier.
Yeah.
So they're already reporting some information to the government, and they already have the obligation. They don't want to interfere or add the burden to have to comply more than once.
Yeah, because I see here investment companies and pooled investment vehicles. That makes sense. RIAs, registered investment advisor. Yeah, we talked about that. You have to report ownership. Sarbanes-Oxley, registered accounting firms, public utilities amongst them. And then also inactive. There's three kinds of exemptions I'm reading here. Inactive entities, right? And there's a definition of what that is. certain subsidiaries and large operating companies, but you got to look at the definition. So if public companies are exempt, that makes sense because there's public disclosure. What about middle market companies? Big middle market companies that are not public,
So,
that may have, I mean, how many, they could have, more than one owner.
yeah, absolutely. So there's a large company exemption, and the exemption, if I can recite it correctly, is you have more than 20 employees.
Okay.
I can't remember if it's at least 20 or more than 20.
More than 20 full-time employees.
Okay. Full-time employees, not just part-time, full-time. That's important.
30 hours per week or 130 hours a month, yeah.
You have a physical presence in the United States. You actually have a business that's operating.
Yes.
In the United States, and you have more than 5 million in gross receipts or sales reported on the prior year's tax return. So if you fit into that those qualifications, you don't have to file a report. Now, as we all know, businesses change.
Right.
So if you don't meet those 3 prongs, you'll all of a sudden have a reporting obligation.
Yeah.
And you'll have 30 days to make that obligation.
So you go from having 21 employees, and maybe you cut, some of them want to go part-time or they're forced to go part-time, and now you're at 19. All of a sudden you go from exempt to non-exempt.
Right.
And you better be on top of this or it's $500 a day.
Yeah.
Wow. And I heard somewhere, I don't know who told me, but about the big 4 are refusing to provide services for this.
Yeah. I mean, I haven't talked to a big 4 accountant, so maybe this is more of rumor.
Yeah.
But that's what I'm generally hearing from colleagues and other professionals that I've talked to about this is the risk of non-compliance, especially with that 30-day deadline, is so concerning. There's not a lot of guidance about how the government's going to enforce the penalties, that they just don't want to get involved in it.
Yeah.
And I was joking with you the other when I started for just talking about this. Like when I move, I forget to update my driver's license. Right. And so, and then I remember the cop. A year after I moved, I get pulled over for speeding or something, and he's like, "You got to update your address," and it's just like, I do. You think I would know, right? But so I went and updated it, but it's going to be this. It's going to be the same thing, I think, for a lot of businesses. And what's kind of insensitive about this law is everybody's information that you put, if anything changes, if the CEO changes, the CFO changes, the CFO's address changes, you're supposed to file an update.
I mean, this is going to create an administrative burden.
Yeah.
I mean, you're looking at adding additional costs here just for compliance purposes.
Right. So you're going to have somebody in your organization, or if you're a small business, you don't have the bandwidth to have somebody do this, you're going to have to be on top of understanding if when this report changes, I'm going to have to go online and make an update.
I see an entire industry of compliance people starting a business right now, providing nothing but compliance to this. I mean, talking to a couple of CPAs, they're still trying to wrap their head around this and how to build it into their model. But this potentially is a disaster from a company's perspective, just from compliance. I mean, here's one more thing you got to worry about that has zero and nothing to do with your day-to-day business. So besides the employees, we talked about the $5 million mark. So you could have a very efficient company that has less than 20 employees making millions of dollars. But then you might have a company that might have 30, 40, 50 employees, but that 5 million threshold, sometimes depending on how they do accounting, they're not going to know if they hit that $5 million threshold past the 30 days.
Right.
Right. So, I mean, this is creating a big time problem. So are the regulations at this point done, set in stone, or are there still things that are being worked out? So
there's a final regulations based on the things that we've talked about who needs to file, how many days you have to make an update or file after you form. What's still left to be issued and finalized is the actual regulations surrounding the system that's being implemented, the BOSS system. And there's some features in that system that are supposed to make it easier for someone to update their information and so through like an issuance of kind of like a key code or key identifier, kind of like a social security number related to this, right? And you would just put in that number and it would kind of update. But that's still outstanding, and we're waiting to hear on that. And I'll tell you, there's one thing to have all these rules, and there's a sample form that's been issued that you could look at. It's another thing to go online and fill it out, right? And everybody's gonna have these gray area questions. What about this? What if this? What if I'm this person, or this happens, and it's not gonna fit in the box? Just like filling out tax returns.
Right.
How do I fit this in the form? And so there's all sorts of judgment calls that people and advisors are going to have to make, and hope they're putting their client in a good position.
Yeah.
When they fill these out.
Yeah, and the timing of this, if you think about it, January 1, if you're prudent, you want to be you want to get this done ASAP because you don't want to mess around. If you start a new business, obviously you got the 30 days. But if you're an existing business, even though there is a year, what's the strategy here? I mean, I would say you probably don't want to be in that first batch while they're working out the kinks. You probably don't want to do this January 1, but you also don't want to wait until later in the year, right? For various reasons. So you got to play that balancing act. So think about it, from a company's perspective. I don't want to be the first in line. So I don't want to do it in January, potentially. February, March, CPAs are getting busy. They're going to be like, hey, let's do this later in the year. Because remember, a lot of the CPAs, they're doing their continuing education for the upcoming tax year that time. So more than likely, this gets pushed over to post-tax season, right? So May, June, then vacations happen. And here we go again, third quarter, where everything happens. It's going to be this blitz that's going to be happening. So I think the recommendation here is start talking to your accountants now. Start talking to your advisors now. Start talking to your attorneys now. Have a game plan, but more so, make sure you have the systems in place inside of your company so that you're able to, if you're on that cusp. I mean, look, for the most part, you're either going to be completely exempt, right? Or you're going to be right in that middle. And besides, these $5 million companies or 20 employees, for the average business owner out there, mom and pop, they got to report this stuff.
Right.
Now, good news for them is they're not changing officers all the time. So, we'll see how that plays out. Now, there was one other thing I read in there talking about companies that have ceased to exist. So if you had an LLC, let's say, and if you've terminated it like you should by filing with the Secretary of State, you're okay there, right? But what if somebody has an LLC, they haven't terminated it, but they're not operating it? It's, maybe it's in a technical default, or maybe it's not. They're just not compliant with the state, but they cease to have any operations, any sales. What do?
Yeah, I mean, I would recommend it's time to terminate. There is this inactive exemption. I think it's there more or less to kind of be a fail-safe, to be fair to some people who just like maybe opened an entity one day and then never did anything with it a few years ago. But if you have an entity that is maybe marginally capitalized or just kind of is just an afterthought, but really doesn't own anything, it's time to probably terminate those entities. Because if the government wants to go after you, that's going to be something that they can kind of claw into. Yeah.
So I mentioned earlier, you're going to be presenting this topic later on this year. When is that?
November at our Chamberlain's tax planning seminar.
Okay. So all the CPAs out there listening in on this, if they want to attend that's in November. What's the date?
November 1st, I think.
November 1st. So mark your calendars, November 1st. Reach out and we'll give you some information on it. Thanks, Jack.
Yeah, sure.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.